Someone has intention but affects a third party, yes. Jasmine Yancey is right. Kind of messed up. I didn't record the first part. Oh well. Thought I had. Do you mind if I back up a little bit? I might have to kind of run through a little bit, but what are we working on? We're trying to define intent. And work on elements and defenses. And then we decided to work on transferred intent. And transferred intent, yes. So even, even though Johnson did not intend to hurt or trip Mrs. Flood, his intent is transferred. The intent element is satisfied if proven, okay? Okay. Is it necessarily proven? No. We are not going to work on final proof. What we're working on is elements alleged not completely proven. So we are, like most courses, most times we deal with fact situations. We have beginning fact situations. And then note fact gaps. So go ahead and note fact gaps as you work through it. Fact gaps always exist, almost always. I mean, it's very feasible, I suppose, that we could get a case in where we actually get full and complete facts. And I suppose the one would be in a case like this, somebody comes in and says, well, hey, I would like to sue this person who is a multi-millionaire celebrity who was trying to intimidate this person, trying to intimidate me, and had the security guard come up and rough me up. Okay, so, and there was a criminal charge that was already done with. We don't care about the criminal charge exactly, but we care about the fact that the facts all came out. Okay, the facts all came out. We can reuse those facts in a civil case. Not all of the facts will be the same in the civil and the criminal case, but some of the elements will be the same. And some of the facts will be the same. In the criminal case, they didn't care about dollar amounts very much at all. They didn't care about pain and suffering very much at all. They cared about somewhat different things, but then they had to prove certain facts beyond a reasonable doubt. We don't in the civil case. But there we might have a full development of the facts. But in most tort cases, when intake comes in, we don't have a full development of the facts. Even in that situation, though, we may not have a full development of the injuries part of it, the dollar amount injuries. And we're also going to talk about essential elements and torts against property. And here's the live classroom word. One of the other things we talked about was that I do prefer charts, tables in Microsoft Word more so than essays, because then it is easier for you and for me to double check and say there is a site for the definition of each tort. And then it's easier to double check that you compared the facts on the one hand with the elements from the source on the other. And I did explain, which I realized was not yet on the recording, that even if another instructor took my course under an assumed name, that person would not get all of the points by just working from memory. I would want them to get a cited definition from the text or lesson content for each tort that they review. And it's easy to do. It's almost easier to do than it is to skip, I would say. It's just a matter of typing it out. Let's look here. Now I've got too many things up. I'm going to do a share. And you say, well, this is too easy. Maybe you won't say that, I don't know. But it's kind of too easy because you can take it right from the lessons. You say, well, why not use it? But then go to the text and understand it in context and see how these things are applied in cases. The same thing with defenses. It's summarized here, but to understand it thoroughly, it's really necessary to go to the text. Torts against property. The only thing that I worry about a little bit is the term chattel, which is from Old English. Doesn't make sense to people, but it's just personal goods that could include large things or small things, but they're anything that's movable. A vehicle could be a chattel. Livestock could be a chattel. Originally, it meant livestock because that was the most valuable thing people owned hundreds of years ago. But now it's any personal goods. A television would be a chattel. Computer, just anything really. Phone, book, anything. Notice trespass to chattels looks almost the same as conversion, but in some states it would be different. Some states would not necessarily talk about trespass to chattels as much. More everything with taking something away from somebody or keeping something that should have been returned would just be called conversion in some states. But look into both of those. in the text, and then look at the defenses in the text too. As we're here, that's, to me, that skimming through there and then find some bolstering in the text is the way to go. There you get the details and the depths to understand what it is you're doing. Do not use statutes, because statutes are limitations. The statutes do not outline the elements of each tort correctly. Very few, I don't know of any states that have described each tort that it can be sued in their state. They use old case law that builds up over time. So I would use the textbook and the lesson content. And like I say, here's the lesson. You get a fact situation, Mr. Larson, Mrs. Larson fighting in the front yard. So this is another one where you say, well, that's only two possible types of laws would be used. No, there's probably several types of laws that could be involved in this. Okay? If Tommy is a minor person, that could be a completely separate matter. He's not one of the Larsons, but he's a Smith. If he's underage and so on, perhaps he shouldn't have even been there. You know, see, there could be juvenile delinquency here, but most likely, since Tommy was not at fault in anything, there could be a child protection case with his parents letting him go over there and that into danger. Okay. But anyway, a young hero tries to save Mrs. Larson from getting hurt. So I would say he's more of a hero than a goat. He's a good guy. Tommy tries to help Mrs. Larson. So he stepped onto the lawn. So technically he's trespassing, but justifiably. Mr. Larson grabbed Tommy and took him into the house against Tommy's will, which sounds obviously like false imprisonment. Mr. Larson did hit Tommy, which sounds like battery. Told him he was going to hit him, which sounds like assault. Going to Tommy's house and kill his mother, that sounds like intentional infliction of emotional distress, or mental distress, as they call it. Mr. Larson went back outside with the intention of shooting Mrs. Larson, but Mrs. Larson stabbed him, but Mr. Larson lived. So that sounds like another possible battery, but also with defenses. But our law firm is going to represent both Mrs. Larson and Tommy. So you're trying to look at torts relating to those items. Explain how torts do or do not relate to this case, and then possible defenses. You cannot totally resolve it because we don't really know Mr. Larson's side of any of this. We're taking it from Tommy's point of view, really, and Mrs. Larson's point of view. We're not trying to resolve it in terms of total proof. We're trying to describe each tort and how it does or does not relate, and then possible defenses. Of course, there are fact gaps. What happened first, second, third, it may matter. One of the things we talked about earlier, I'm going to answer the questions in a bit, okay? Two or more legal aspects to human problems. And I like charts or tables. some are very complex. This is actually not that complex. There's a criminal and a civil treatment that are completely different. So somebody gets hit and the person hit gets injured. The tort treatment is that John hires Amy, an attorney, who sues Bill for money. Amy Yancey is a private attorney. She can't also charge Bill with the crime. So tort, there's a very big division between tort and crime. Crime is a completely different set of laws. Yes, it could be on the same facts, but it's a completely different law. A criminal treatment of the same facts that could be separate, would be separate, and you don't know if either or both of these, when you take in a case, you don't know if either or both of these are going to happen as far as a tort or a crime or both. You don't know. But it's possible that Officer Edward would charge Bill with a crime, and then Attorney Johnson might prosecute as Assistant County Attorney. But if Assistant County Attorney Johnson does this, that person cannot also sue Bill, just as Amy Yancey, private attorney, cannot also charge Bill with the crime, can only do the civil tort lawsuit. Same fact situation, multiple laws. Let's say that Bill and John are also disputing over John's wife, who is contemplating divorce, they're also disputing over an estate. So one complex set of facts that comes into a law office may involve a tort action, probate, family court, restraining order violation, and a bankruptcy. All different laws, all handled under different laws. So the fact that doesn't make the laws the same. Each fact situation involves a human problem that may be not all that complicated from a certain human aspect, but it may involve multiple types of laws. And Amy is asking, why isn't legal terminology updated to replace chattel with personal property? Because they're based on old cases, and the old cases sort of become unreadable if we don't learn the old-fashioned terminology. That would be my best guess. So we're still probably they're gonna call it, they've called it trespass to chattels and, conversion of chattels for so many years that it's hard to change it. Jasmine, for the Module 3 written assignment, either a table or a numbered list or a essay is required. My preference is a table just because it's easier to check. And a cite for each tort, and we can cite the lesson content in the textbook. Yes, I want a cited reference for every tort, and then cite the lesson content in the textbook. Yes, that's absolutely true. That's what I want, because I can more or less see you students working your way through the textbook and the lesson content and learning more things, even though some of you already know a lot, and I realize that, but I don't want your memorized knowledge. I want your new reading to show. And then this is the key, really. The difference is the type of legal action and the consequences. Conduct is not really different, but obviously the result is much different. The result in the laws are much different. If somebody is prosecuted for a public crime, So if somebody is sued for a tort and loses, results as a money judgment. Prosecuted for a crime by the state and loses, results as punishment. And we've kind of been over this by screen sharing. This is Larson, plaintiff, Tommy plaintiff, Mr. Larson defendant. We're not going to look to state statutes. That's a big error. I don't agree with that in the course. Not something I can change. It's a difference of opinion. See no point in state statutes. They're always wrong. Now, there could a state could pass statutes, but very few states ever define torts by legislatures. Most still use old English and U.S. common law. Judge-made law. So I want text and lesson content. Avoid statutes. I think you two see the point of not using statutes. Yeah, statutes are a problem. They're a major problem because you get two types of statutes cause more confusion and ruin learning. So you get criminal statutes and limitations. So what have you learned by finding out that it takes, let's say that there's a 6-year statute, not basics? And what have you find out where there's a battery crime, not basics? Okay. It just creates confusion, so we don't want that. You can take, and I believe most of you all will take a criminal law class, so don't do it here. Text. And you may use state cases, not statutes. Okay. Unfortunately, like I said, it's sort of built into the course. Common law. The text is a better source than trying to start from scratch with case law. If the text is too easy, use cases, okay? I have not seen a state that set out in tort law clearly really did it. And figure out what facts satisfy an element, what facts in the story. And then the defense is Now, you can speculate on defenses that are not clear from the story at all. Okay? You can speculate on that if you wish. You don't have to. And then neither is required. It just makes it more sort of understandable. Okay? As I pointed out, we are focused on tort only. There could be multiple laws involved with a given fact situation. Human problems don't seem to fit neatly into one specialty, and that's part of why I want you to take all your courses seriously, because you think you have it figured out because you and the lawyer you work for are working on one type of law. Oh, this is definitely a tort law case. Yeah, it may be a tort law case from your point of view, but you or your boss, the lawyer, should still include in the advice letter that they should pursue other legal elements of the case if where you work for does not handle other types of law, then it should be a referral. And vice versa. If the case came to, if there's multiple areas of law involved or two or more areas of law, just being able to spot that there's issues from other areas of law definitely helps. I mean, what was the initial dispute about? It doesn't say, does it? Was it a typical family law dispute? Was it something to do with arguments over debt, probate? May have even been argument over something. Maybe Tommy knew that this was coming because it involved his parents, that they were fighting over or something. You know, one side, maybe they were arguing about a border fence, and one of this married couple decided that they should, let's say, Mrs. Larson wanted to go easy on Tommy's parents and not get in a battle with them, you know. There's all kinds of things that can happen. Look at possible defenses. Immunities does not apply to our fact situation. It's just another thing to read about. Oh, not part of the story. Okay. Do you have a question about fact gaps, Jasmine? Fact gaps is just the fact that we didn't give you all the facts because it would probably go on to several pages in a genuine human situation. Sometimes you look at the elements and you look at what we gave you and you say, the answer is don't know. But we're not trying to get you to finally decide it. Just analyze what's there and look at possible options And then the same thing with the torts. You say, well, this is a possible tort. Do we know all the facts? Do we know what Mr. Larson would say? Do we know if there was any video footage taken of the whole situation? No, we don't know all that. So we don't know what happened first, second, and third. What happened inside the house, we don't know. True. But just analyze what we've got and try to organize it for the supervising attorney, basically. And this is basically dog attack, dog bite thing. And then, of course, for a dog attack or any discussion, start a post, reply post, at least one cited source, one of your two posts. Best would be case law. Okay. Questions or problems? And then remember Iraq, that we want to own state is best, yes. If you cannot find anything, no one's ever been sued for a dog bite in your state, then had to appeal, and where the Court of Appeals or the Supreme Court of your state had to rule on it. If that never happened, of course, you can look in another state. And I am promoting Justice Studies Club. If you want to join, go to Facebook. This is voluntary you can look for Rasmussen College Online Justice Studies Club on Facebook. It's a private, not because it's private in the sense that it's for Rasmussen students and alumni, faculty, staff, and so on. The LinkedIn one I've considered, I haven't gotten anybody, but I've considered having people join the LinkedIn who are not necessarily Rasmussen, but who are lawyers who would consider hiring a Rasmussen grad, but I haven't got anybody in from that category. They're all students, alumni, faculty, and staff, and that's the reason why it's private. I don't want everybody to come in who has no connection to Rasmussen, okay? That's why I did it that way. It's really a co-curricular of Rasmussen now. It's become official. Rather than it started out being sort of official. Then the person that had the authority to do it sort of left the college, and then I took it over and I sort of made it somewhat unofficial. Then we made it an official part of Rasmussen co-curriculars, so it's kind of plays different roles. And join if you wish, and it takes a little while because I have to see that you've applied, and then I'll put you in. Thanks for visiting with me.